There are some new updates with the OnPassive litigation with the SEC. Mufareh and top OnPassive leaders have been busy. So without further ado, let's get right into it.
Karma's a bitch.
Queen of Karma.
On September 30th of 2024, a document was filed entitled Document 45. It states, defendant's notice of withdrawal of certain affirmative defenses. If you remember, Ash tried to have the case dismissed with a whole set of lawyers. Please take notice that defendants Ashraf Mufareh, OnPassive LLC, and Asmahan Mufareh, Ash's wife, hereby withdraw the 1st, 2nd, 3rd, 5th, 9th, 10th, 11th, 12th, 13th, and 14th affirmative defenses of their answer filed on September 10th, 2024, which I covered here on my channel. This notice of withdrawal does not constitute a waiver of any of these defenses, and defendants reserve all rights to pursue such defenses in this litigation. Defendants also reserve the right to further amend their affirmative defenses. On January 10th of 2025, there was a time-sensitive motion for miscellaneous relief, specifically to split time evenly at the deposition of third-party witness Jeffrey Morlock by Ashraf Mufareh, OnPassive LLC, Asmahan Mufareh, and it was referred to the judge. And I know what you're thinking. You're like, Jeffrey Morlock? Yeah. This is it here, and we're going to go through it now. It is Document 46. Pursuant to Federal Rule of Civil Procedure 30D1, defendants Ashraf Mufareh and OnPassive LLC and relief defendant Asmahan Mufareh, together defendants, by and through their undersigned counsel, hereby file this time-sensitive motion to split time evenly at the deposition of third-party witness Jeffrey Morlock, scheduled for Tuesday, January 21st, 2025, such that the SEC and defendants are each entitled to 3.5 hours of questioning. Because the deposition is scheduled to take place in less than 2 weeks, defendants respectfully request that the court treat the motion as time sensitive, such that a ruling may be issued by Friday, January 17th, 2025. Wow, what a busy day that is. Before the holiday weekend. As grounds in support of the motion, defendants state as follows. On December 17th, 2024, the SEC and defendants, together, the parties, jointly selected January 21st, 2025 as the date most convenient to depose third-party witness Jeffrey Morlock. He's been called as a third-party witness. On December 18th, 2024, the SEC served Mr. Morlock with a subpoena to testify at a deposition in a civil action on January 21st, 2025, and provided defendants notice of the same. On January 7th, 2025, defendants served Mr. Morlock with a subpoena to testify at a deposition in a civil action on January 21st, 2025, and provided the SEC notice of the same. Defendants proposed dividing the deposition time evenly between the parties and offered to yield any extra time to the SEC because it served its subpoena first. And it says, see Exhibit A. We will take a look at Exhibit A after this. On January 8th, 2025, the SEC refused to limit its deposition to 3.5 hours. In response, defendants explained that when both parties to a litigation seek to depose the same witness, generally accepted practice is that they split the time evenly or agree in advance on some other allocation. This is so weird. The SEC then asserted it was entitled to 7 hours under the rules, but might be able to agree to reserve 2 hours for defendants' question. Okay. On January 9th, 2025, defendants offered to take 3 hours, leaving the SEC with 4 hours, explained that the SEC had already questioned Mr. Morlock under oath during its investigation, so he's already been questioned, and that defendants required more than 2 hours as it was their first opportunity to question him. On January 9th, 2025, the SEC refused to yield and instead proposed that if the deposition were extended to 8 hours above the presumptive 7-hour limit set by Civil Procedure 30D1, it would be willing to take 5 hours for deposition, leaving 3 hours for defendants' questioning. On January 9th, 2025, defendants rejected the SEC's proposal and renewed their offer to allocate 4 hours of questioning to the SEC and 3 hours of questioning to defendants. On January 10th, 2025, the SEC again refused to back off its demand for 5 hours of testimony from Mr. Morlock and represented that it undertook the effort to contact Mr. Morlock and that he agreed to start at 9 a.m. and stay later in order to accommodate both of our time requests for the deposition. Later on January 10th, 2025, defendants also contacted Mr. Morlock. He explained that the SEC told him, 1, that he was required by law to sit for 2 separate depositions of 7 hours each for a total of 14 hours of questioning, but 2, that if he agreed to start the deposition earlier, it could be completed in 1 day with less than 14 hours of testimony. Mr. Morlock also explained that he agreed to arrive early in the spirit of cooperation. Oh, please. And because he believed that otherwise he would have to provide up to 14 hours of testimony. Defendants now seek the court's intervention under Federal Rule 30D1, which presumptively limits a deposition to a single day of 7 hours. And then Rule 30D1 limits a deposition to 1 day of 7 hours unless otherwise authorized by the court or stipulated by the parties. First, when parties cross-notice the deposition of a third party, it is widely accepted practice for parties to agree to an allocation of time to question the witness. Despite defendants' efforts to find a compromise, including offers to yield any leftover time to the SEC or to give the SEC 4 of the 7 hours, the SEC has refused to agree to an allocation that permits defendants sufficient time to question Mr. Morlock under oath. Second, defendants respectfully submit that Mr. Morlock, a third-party witness who is 65 years old, should not be deposed for more than the maximum amount of time contemplated under Federal Rule of Civil Procedure 30D1, which specifies the same time limit for depositions of even-party witnesses. Third, the SEC has already obtained sworn testimony from Mr. Morlock as part of its pre-litigation investigation. His testimony, which was taken under oath, lasted approximately 3 hours. The SEC has provided no persuasive justification for why it needs 7 hours to conduct its second round of questioning. Fourth, defendants have never had the opportunity to question Mr. Morlock under oath, as they were not invited to participate in the SEC's initial questioning of Mr. Morlock. At a minimum, defendants are therefore entitled to half of the allotted deposition time. Fifth, the SEC's suggestion that the time for Mr. Morlock's deposition be extended past 7 hours does not resolve the issue. Not only does it prejudice the non-party by requiring him to sit for additional hours of questioning, but the SEC offers no good explanation as to why it should be entitled to more than half of the total time, regardless of how long that may be. For the foregoing reasons, defendants respectfully request that the court grant defendants' motion and enter an order that the parties must split the time evenly at the deposition of third-party witness Mr. Morlock. Because Mr. Morlock's deposition is scheduled for Tuesday, January 21st, 2025, defendants respectfully request a ruling by Friday, January 17th, 2025, before the holiday weekend. Wherefore, the defendants respectfully request that defendants' time-sensitive motion to split time evenly at the deposition of third-party witness Jeffrey Morlock be granted, and or that the court grant other and further relief the court deems just and proper. So let's have a look at Exhibit A. Lydia is Mufareh's new lawyer. So this is from her to the SEC. Please find attached a notice of deposition and subpoena that we plan on serving on Jeffrey Morlock. Given that you have already served him and set a date, time, location, we have conformed our subpoena to those logistics. We anticipate that we will need several hours to question Mr. Morlock and thus propose that the deposition time be split evenly as between the SEC and defendant. As you served your subpoena first, we are happy to let the SEC start with its questioning. If you prefer, we will start, and to the extent we finish in less than 3.5 hours, we'll yield any extra time to you. Please let us know your preference so we can get this squared away in advance. Best, Lydia. and that was sent January 7th. The same day, they respond, "Hi, Lydia. We have no objection to your cross notice of deposition on Jeffrey Morlock. However, we do not agree to limit our deposition to 3.5 hours. While it is possible that we do not use the entire amount of our allotted time, under FRCP 30D1, we are entitled to use up to 7 hours. We can't predict at this time how much of those 7 hours we will ultimately need, but you are welcome to use the balance of whatever time is left after we finish. However, if you expect to need any significant amount of time, you may want to reach out to this witness to see if he is willing to stay longer that day, or whether he would prefer a separate deposition day. Seems fair?" So Lydia responds on January 8th. Mr. Morlock is a third party, and neither the federal rules of civil procedure nor the local rules require him to sit for more than a single 7-hour deposition. When both parties to a litigation seek to depose the same witness, generally accepted practice is that they split the time evenly or agree in advance on some other allocation. Now, this is a thing. The SEC is saying we might need the 7 hours. We don't know yet. So you need to do a second day or make sure he can stay for another up to 7 hours if that's what you're, doing. So maybe do another day with him, a separate day. So he'll be doing 1 day with us and 1 day with you. And it doesn't sound like they want to do that. We are available tomorrow if you would like to meet and confer further. Best, Lydia. So he responds, "Lydia, as I mentioned below, we are entitled to 7 hours under the rules, but we might be able to agree to reserve 2 hours for you. It is likely that we will need the full remaining 5 hours. If you think you will need more than 2 hours, FRCP 30D1 provides that time can be extended by stipulation or by court order. In fact, the notes to the rules expressly provide that in multi-party cases, the need for each party to examine the witness may warrant additional time. If you wish to approach the witness and ask him to consent to stay a little longer in the event it is necessary, we are happy to stipulate to that. In the alternative, you may ask the court for additional time, and we will not object to any such request." Again, they're saying we might need like 5 hours with him. If you want to do your own deposition, since this is our deposition day, and we're allowed up to 7 hours by law, and you don't want to only agree to 2 hours, then set up your own day. And she's going, "No, I don't want to. I don't want to do that. I'm allowed half of your time. You have to cut your time in half for me." And it's like, that's not what the law says, though. So she responds on January 9th and says, "As you know, this will be Mr. Mufareh's first opportunity to question Mr. Morlock. Well, the SEC has already deposed him once, which they're allowed to do, and that wasn't the official one, right? That was just the investigation. Now he's actually going fully on record for all of this for the courts. It's a little bit different. So your suggestion that the SEC will take 5 hours of this second deposition, leaving Mr. Mufareh only 2, is untenable. See, she doesn't understand that she can set up a whole day where they can have 7 hours. In an effort to compromise, we can agree to a division of the time for this witness where the SEC takes 4 hours and Mr. Mufareh takes just 3. If the SEC will not agree, we will seek guidance from the court. Best, Lydia." And it's like, you're trying to cut into their time with him, though. Like, what? So the SEC responds January 9th. "Lydia, the testimony that the SEC took during the investigation was not a deposition and does not count as a deposition under the federal rules. There are numerous reasons why we believe we need 5 hours to depose him, including the fact that thousands of materials that have been produced to us since his testimony was taken, including more than the 12,000 items that he produced. Nonetheless, as I mentioned earlier, while 7 hours is the default amount of time provided for depositions, the rules provide that the parties may stipulate or approach the court to obtain additional time. You have indicated that you would be satisfied with 3 hours of time. It may be simpler to ask Mr. Morlock if he would be willing to stay an additional hour. If he agrees, we are happy to stipulate to more time to provide you with 3 hours. If you prefer to go to the court, that is fine too. We will not oppose a request for an additional hour of time for you to depose Mr. Morlock." Yeah, but they don't have to cut their time short, right? So she responds on January 9th. Your suggestions are plainly unacceptable. Unless you can agree by 10 a.m. Eastern tomorrow that the SEC takes 4 hours and Mr. Mufareh takes just 3, we plan to seek the court's intervention, at which point we will ask that the court split the time evenly between the parties. Best, Lydia. I don't know if that's, I think she's reading that law wrong. So the SEC responds to Lydia and says on January 10th, I am not sure what the disagreement is here.
Uh-oh, he's getting angry.
We noticed this deposition more than 3 weeks ago. Although the rules provide for 7 hours of deposition time, when you cross-noticed the deposition this week, we agreed in the interest of cooperation to grant you 2 of those 7 hours. We are reserving 5 hours because we believe we need that time to depose this important witness. In addition, we also agree to stipulate to an additional hour of deposition time to allow you the full 3 hours that you indicated you needed. And if you now think you need 4 hours, we're willing to stipulate to that too. In order to preserve judicial resources, we suggested that you approach the witness to get his agreement to stay an additional hour or 2, if that is what you now think you need. We also told you that we won't object to you approaching the court to ask for additional time if that is how you prefer to handle it. You have chosen to do neither. Instead, you have threatened to file a contested motion to ask the court to deprive the SEC of 1.5 hours of time to depose an important witness under the guise of obtaining deposition time that the SEC has already agreed to. I know, it's ridiculous. If you move forward with that motion, we will oppose and reserve our rights to seek whatever remedies might be appropriate for what we believe to be a waste of resources. Thanks, Lydia. So she responds on January 10th and says, the SEC cannot unilaterally decide that it is entitled to more than half the deposition time allowed under the federal rules and local rules, nor can the SEC unilaterally place the burden on defendants to resolve the SEC's desire for more time than that to which it is entitled. And of course, Mr. Morlock is not under any obligation to voluntarily sit for more than a 7-hour deposition. Our point in raising that you have already questioned Mr. Morlock under oath is that this prior questioning should enable you to efficiently conduct his deposition on January 21st. We are clearly at an impasse and will be filing our motion this morning, attaching this correspondence so that the court understands why its intervention is necessary. No, thank you, Lydia. Thank you for that. It's been very helpful. So the SEC responds and says, as noted, we disagree. However, if you would like to send us any authority for your position by COB today, we're happy to take a look. Thanks. That was at 12:55 p.m. on January 10th. And a couple hours later, they respond with, counsel, we just wanted to let you know that we undertook the effort to contact Mr. Morlock ourselves, and he has agreed to start at 9 a.m. and stay later in order to accommodate both of our time requests for the deposition. If you agree to these arrangements, please let us know so that we can modify the subpoena and our travel arrangements. If you insist on filing your motion, please ensure that you inform the court of this notice. On January 13th, an endorsed order denying without prejudice 46 motion to split time evenly was filed. The motion fails to include a memorandum of law in violation of Local Rule 301A. Any future motion must include a memorandum of law providing citations to legal authority supporting the movant's request. Additionally, the defendants did not raise this dispute with sufficient time for the court to address the issues in regular order, right? Therefore, the court will quash the defendant's subpoena of Mr. Morlock. All future motions must be filed with sufficient time for the opposing party to respond pursuant to and within the timeframes of the local rules and for the court to issue its ruling. From the judge. And then on the 21st, after all of that, of January 2025 is when this was filed by Lydia, the appearance of counsel. And I was like, why are you filing that now?
I'd say we're off to a great start.
Great lawyer you got here, Ash Mufareh. But it says the clerk of court and all parties of record. I am admitted or otherwise authorized to practice in this court, and I appear in this case as counsel for defendants Ashraf Mufareh.
My name is Ash Mufareh, and I'm your friend.
OnPassive LLC and Asmahan Mufareh, again his wife. I did take out any identifying information, as I always do. So it sounds like they were kind of trying to mess with Jeffrey Morlock's deposition. And luckily for us, the Recovering Hunbot has released an article explaining everything. OnPassive Leadership Council member Jeffrey Morlock deposed in SEC case after scrubbing YouTube channel of incriminating evidence. Links will be down below. One of the first OnPassive Leadership Council members is subject to 7-hour deposition with the U.S. SEC. Mr. Morlock's subpoenas. Jeffrey Morlock, an OnPassive Leadership Council member, is the first publicly confirmed party to be deposed in the ongoing civil case brought against Ashraf Ash Mufareh, OnPassive, and Asmahan Mufareh by the United States Securities and Exchange Commission. This was revealed in an electronic case filing entered on January 10th, 2025. Per the original case management and scheduling order, both the defendants and complainant are allowed no more than 10 depositions each. This stipulation remained unchanged in the amended case management and scheduling order issued on September 14th, 2024. Both parties have until June 2nd, 2025 to file any discovery-related motions with the court. Mr. and Mrs. Mufareh's objections. On January 10th, 2025, counsel representing defendants Mr. and Mrs. Ashraf Ash and Asmahan Mufareh and OnPassive LLC filed a motion in opposition to the stipulations on Mr. Morlock's deposition scheduled by the SEC. They specifically objected to the SEC having a full 7 hours of questioning with Mr. Morlock, requesting the 7 hours be split evenly between the SEC and the defendants. This filing revealed that the SEC served on December 18th, 2024, Mr. Morlock with a subpoena to testify at a deposition in a civil action to take place on January 21st, 2025, following agreement between the SEC and defendants the previous day. Subsequently, on January 7th, 2025, the defendants served Mr. Morlock with their own to testify at a deposition in a civil action, also to take place on January 21st, 2025. The defendants notified the SEC of their own subpoena, proposing to split the time evenly between both parties, yielding any remaining time to the SEC. It's so weird. On January 8th, 2025, following the defendants serving their own subpoena to Mr. Morlock, the SEC refused to limit their deposition to 3.5 hours, and it's their legal right to do that, in an email between the SEC and the defendants' counsel. The SEC asserted they were entitled to 7 hours under the rules, but might be able to reserve 2 hours for defendants' questions. On January 9th, 2025, defendants' counsel offered to take 3 hours of the 7-hour deposition, leaving the SEC with 4 hours. In response, the SEC counter-offered them, taking 5 hours and giving the defendants 3 hours, increasing the total deposition by 1 hour from the original order. How annoying. On January 10th, 2025, the SEC continued to demand 5 hours for their questioning, and Mr. Morlock had agreed to start at 9 a.m. and stay later in order to accommodate both of the parties' time requests for the deposition. Later that day, defendants contacted Mr. Morlock, at which time Mr. Morlock explained the SEC had told him that he was required by law to sit for 2 separate depositions of 7 hours each, but that if he agreed to start the deposition earlier, it could be completed in 1 day with less than 14 hours of testimony. After failing to come to agreement with the SEC, Mufareh's counsel sought the presiding judge's order to limit the deposition of Mr. Morlock to a single day of 7 hours. Defendants' basis for objection. Per the filing, the defendants objected in part because the SEC had previously obtained sworn testimony from Mr. Morlock. That testimony, which lasted approximately 3 hours, was obtained as part of the SEC's pre-litigation investigation. In other words, Mr. Morlock was one of an unknown number of parties interviewed by the SEC prior to filing their initial complaint with the courts on August 11, 2023. The defendants also objected to not being invited to participate in the SEC's initial questioning of Mr. Morlock. Therefore, per the filing, the defendants felt entitled to half of the time allotted for the January deposition. I think they all just feel entitled. End of sentence. The defendants also appeared to imply expecting depositions totaling more than 7 hours was unfair due to Mr. Morlock's age. Oh, but it wasn't unfair to have him sign up for a pyramid scheme? Defendants respectfully submit that Mr. Morlock, a third-party witness who is 65 years old, should not be deposed for more than a maximum amount of time contemplated under a federal rule of civil procedure, which specifies the same time limit for depositions of even party witnesses. This is, to us, a laughable argument, as Mr. Morlock has regularly attended OnPassive corporate webinars in excess of 7 hours. Has he ever? He also seems to have no issue speaking at length on said webinars or as guests on other webinars. Agreed. And then also doing his own videos after them. Mufareh's motion denied. 3 days after the motion was filed, Magistrate Judge Robert M. Norway denied the motion to split time evenly. The Honorable Norway claimed the motion failed to include the memorandum of law in violation of the court's Local Rule 31A. The Honorable Norway also ordered any future motion must include a memorandum of law providing citations, the legal authority supporting the movant's request, and noted that the defendants did not raise the dispute with sufficient time for the court to address the issues in regular order. The court quashed the defendant's subpoena of Mr. Morlock. Mr. Morlock's YouTube channel scrubbed of incriminating videos. Jeffrey Morlock has maintained a YouTube channel since August 17th, 2018, which happens to be when Mr. Mufareh began recruiting founders into the OnPassive opportunity. His channel was originally under the name Jeffrey Morlock OnPassive Leadership Council. I've always wondered, was he the first one to join the Leadership Council? And like Marty DeGarmo, he has since changed it to remove any reference to OnPassive and the OnPassive Leadership Council, shortening it to the generic @Jeffrey Morlock handle. And now you know what tipped them off as to why maybe they should change their channels. Maybe they don't know about OnPassive shutting down and turning into a new company, but they did know about Jeffrey Morlock getting subpoenaed. Prior to Mr. Morlock's deposition with the SEC, his YouTube channel was scrubbed of all recorded videos posted prior to March 16th, 2021, and all live stream recordings prior to March 25th, 2022. Whether this was done to prevent being questioned about the contents of those videos, we cannot say with certainty, but there was no reason to remove those videos, according to YouTube master marketers Marty Don DeGarmo.
Don't panic.
And Mike Ellis.
I'm Mike Ellis, by the way,
who claim every video is a recruitment and marketing opportunity. Fortunately, as with all prominent OnPassive promoters, we have a complete archive of the contents of Mr. Morlock's YouTube channel. We have identified at least 48 recorded videos Mr. Morlock has deleted from his YouTube channel. In addition to removing any references to OnPassive in his channel name, Mr. Morlock has also removed his channel profile description. Again, we're lucky enough to have a record of what he previously posted in his YouTube biography. One of his earliest bios read, and here's the thing, Jeffrey, I did a deep dive on you. OnPassive is a unique, revolutionary artificial intelligence information technology company set to completely change the online model. It's the first digital technology-driven startup of its kind to apply its prowess to online marketing and will severely disrupt core, old model online marketing businesses, much the same way Netflix did for video, Uber did for transportation, Airbnb did for hospitality, or PayPal did for payments. It's like those businesses are the new model for their market. OnPassive is the new model for marketing and beyond. For marketing and beyond. Right now, OnPassive's ahead of the market by 3 to 5 years. Check out what our CEO said recently. You pay and you own the world. That's it. That's what OnPassive is. Everything you need to communicate, to learn, to educate, to earn, to connect with the world, to promote your business, to any activity that goes around your daily life. Today's life is already in OnPassive. Once you make that payment, the light goes on. Mufareh, October 20, Another iteration of his YouTube bio read, "About 5 years ago, I started a very personal journey, a journey of the soul. Throughout this personal journey, I've also been on the OnPassive journey. Wow, what a journey this has been. Anyway, we are in a very good spot right now, and I am ready to be in the best shape of my life. Right now, OnPassive is shaping up a centralized message for the world about who we are, why we are so different. Getting ahead of that, because OnPassive is a brand, and I know it will be a household word before long. My YouTube and LinkedIn channels have had a makeover, and I am taking this opportunity to start making short videos about waking up, raising consciousness, and lifting humanity. I have left some of the thought-provoking videos up. I hope you join me. It really is going to be quite spectacular, and I would love the company. Many blessings. OnPassive is a unique, revolutionary artificial intelligence / information technology company set to completely change the online model. Rather than just describe the videos that Mr. Morlock has deleted, we have decided a short compilation of what Mr. Morlock said in these videos would be left right here. They range from unfounded income claims, outright false projections regarding the launch of OnPassive, talk of bonuses, and more. All of these issues form the basis for much of the SEC's claims against the Mufarehs and OnPassive. And I am going to leave a link to this article down below, and if you want to watch this video, you can head on over and watch it directly from the website, or you can go over to the Recovering Hunbot's channel and you can watch it over there. Please do. It's quite eye-opening. Again, it's interesting that these videos have been scrubbed by Mr. Morlock, but we can only speculate. The selective removal of videos from Mr. Morlock's, as well as those channels belonging to other OnPassive founders and leadership council members, only make OnPassive, the Mufarehs, and others look more guilty of the accusations put forth by the U.S. Securities and Exchange Commission. I don't want to toot our own horn or anything, Hunbot, but we've kind of proven some things over here too. Stay tuned for more updates regarding the civil case against OnPassive and more information on the pending launch of OnFusion Technologies. That is, if Vibe doesn't steal all the OnPassive Oat founders first. And that is the latest update with the SEC versus OnPassive. Again, links will be down below for the Recovering Hunbot's website post so that you can go and watch the video of Jeffrey Morlock. I believe she also covered this on her channel and played the video then, so you can also go check that out. But please do make sure that you at least go give her website a visit. Just go click on the link. Thank you so much for being there for me through all this. Oh, Marty.
Don't panic.
The SEC is never going to.
Stop going there.
But it's okay because, you got friends, right? Let me know all of your thoughts about this down below. I want to hear everything you guys have to say always. And stay tuned to the community tab. I will see you all very, very soon with another one. I love all of your faces. Mwah! Bye. Yo, SEC. Yeah, you know me.
Queen of Karma.